All right. So my name's Josh Reed. I'm an associate professor of history and American Indian Studies at the University of Washington. Last time I was here in Missoula, I was passing through on my way back home to start my gig at the UW. So excited to be back out here. So today we're just going to go ahead and go in order on this panel on perspectives on tribal law and policy in the rural West. So Monty, why don't we go ahead and start with you?
Good afternoon, everybody. My name is Monty Mills. I'm an assistant professor and co-director of the Marjorie Hunter Brown Indian Law Clinic at the University of Montana here, the Alexander Blewett III School of Law at the University of Montana. That's a new name, and since I'm new at the school, I'm having much easier time of saying the name than some of those who've been at the school for a while. Just on a personal note, I want to thank those who allowed me to be here before you today. Having grown up, spent all of my life in the West and grown up in the rural West, it holds a special place in my heart, but so I really appreciate being able to participate, particularly on a panel with the esteemed guests we have today. So I had prepared to talk about conflicts that I saw between the exercise of tribal sovereignty and rural communities, particularly states and local communities in the rural West. And I had thought to do that, particularly in light of a pending Supreme Court case about the potential diminishment of a reservation in the state of Nebraska, and how the issues in that case really resolve around whether or not the settled and justifiable expectations of a local non-Indian community can support an argument that a reservation should no longer exist around that community. And I had thought to do that in the context of the history of federal Indian law and policy, and trace the development of that reservation, along with the eras of federal Indian policy, including particularly allotment. But having sat here for the day and listened to the fascinating and excellent panels and discussion, I thought that there's a parallel conversation here that kept coming to me in my experience about issues in the rural West, and not the conflicts between Indian country and tribes and tribal governments and the rural West, but a different perspective about the way that tribal governments and tribes themselves are dealing with the very issues that many of the panels here have been talking about. And that's a conversation that I think it may be worth considering for future conferences on the rural West, particularly because I think that there is a high value in hearing the perspective of tribal governments and tribal leaders, their view on these issues and how they seek to address them. So I'd like to talk a little bit about that, and I made a list of some of the issues that came up throughout the day that I think are relevant, particularly in the context of tribal law and policy and the exercise of tribal sovereignty. And it really started last night at the dinner. Those of you who were there saw a fascinating sort of proposal and potential discussion about a trail crossing the Northwest. And my immediate sort of reaction to that was, well, I wonder to what extent the federal government's obligation to consult with Indian tribes is playing in that particular project. And I wonder to what extent there are opportunities for cultural education about tribal uses of those areas. And I wonder to what extent, if it does cross Indian land, there are rights-of-way on those Indian lands, and whether or not the federal government will process those rights-of-way in a timely fashion. And then this morning we talked about broadband expansion, and broadband expansion into Indian country is a very pressing issue. In fact, a number of tribes have been working with the FCC to address broadband access and internet access in Indian country. And beyond that, running cable fiber optic lines into Indian country requires rights-of-way across Indian trust lands, which requires not only the consent of the Indian tribe, but approval from the federal government. And the bureaucracy associated with the approval of those rights-of-way can often cause delays, and tribes may not be willing to consent to lines running across their tribal trust lands. Beyond that, we talked about meth and the meth epidemic. And this is an issue that a number of tribes here in Montana are also struggling with. They're considering how to deal with meth use, and particularly meth dealers, many of whom may not be tribal members, and over whom they have no criminal jurisdiction, because the Supreme Court has said tribes exercising criminal jurisdiction over folks other than Indians is inconsistent with their status as dependent domestic nations. And so tribes here are thinking about, well, can we banish these people from our lands? How do we go about doing that? Can we do that lawfully in the context of the Indian Civil Rights Act? How would we do that? We also talked about the transfer or potential transfer, and in some cases the desire to transfer federal lands to the states, which is a fascinating issue, particularly when you think about, for example, in the Malheur Wildlife Refuge, that land actually never was part of the state. It was Indian land and then federal land. So to transfer it back to the state or to the citizens of the state is really inaccurate, because it never was the property of the citizens of the state. It was either Indian land or federal land. Interestingly, a more recent and local development related to the transfer of land relates to an announcement from the U.S. Fish and Wildlife Service just within the last couple of weeks that that service is considering the potential transfer of the National Bison Range, about 45 minutes, maybe an hour north, back into trust status for the Confederated Salish and Kootenai tribes. Is that a transfer that raises similar issues to the transfer of federal lands back to the states? I don't think so. I think the relationship between Indian tribes and the federal government is different. And yet, there has been opposition to the suggestion that tribes should exercise management authority over federal land. We also talked about, there was mention this morning about the relationship between Montana and other states with regard to the transport of Montana coal across those states. That very issue has raised interesting tribal issues as well, because the Crow, or the Apsalalke Nation just to the east, are heavily dependent on coal development. And as part of their strategy for economic development, transport of that coal to the coast for sale to China is a necessary component of their economic development. And yet not only do the states to the northwest oppose transfer of coal across their lands, other tribes with treaty rights who exercise their treaty rights in fishing and shellfish gathering in the northwest also oppose the transfer of coal, and particularly the coal ferries that would be required to load that coal on ships and send it to China. In addition, we had a panel about the sense of place, and there were questions raised about, well, what role does the indigenous sense of place play here? And I think those are also issues that deserve more full exploration and discussion, particularly as it relates to connections between Native communities and sacred sites that are on public lands, and an area, again, where the Supreme Court has severely limited the rights of Native people to access and utilize those sites for their traditional and cultural practices. We talked about the importance of fishing in the sense of place. Tribes have been exercising fishing rights since time immemorial, rights protected by treaties that are centuries old. Those rights, both to hunt and fish, are connected to certain locations, usually, as was mentioned this morning by Mark, unoccupied lands of the United States. Do states, when they join the Union, have the right then to ignore those rights and prosecute tribal members who hunt in accordance with those treaties, even if it's outside the seasons that the states set? It's an issue that there's litigation pending right now in Wyoming about the interpretation of those century-old treaties and those treaty rights that date since time immemorial. There was mention of Facebook and the role Facebook plays in the rural West. I can tell you from my experience working in a tribal community, there were issues that I had no idea were important because I wasn't on Facebook. And those issues and the discussion on Facebook largely drove tribal governmental policy in some areas, because tribal leaders saw their constituents and their comments directly. There wasn't any separation between the governing and the governed. Sometimes those governed didn't know that their tribal leaders were viewing their Facebook comments and that policy was being affected by their own commentary on social media. We talked about housing issues. Clearly an issue in Indian country as well, including cultural connections that often result in numerous individuals living in the same home. We talked about wilderness skills, talked about food security, and those, to me, raised issues about subsistence hunting and fishing, particularly in Alaska. Both Alaska and Hawaii have been mentioned as Are they part of the rural West or not? I think those are fascinating issues to consider, particularly in the area of Native rights, both Native Alaskans and Native Hawaiians, where in both situations, there's potential for significant redefinition about the legal rights of those people. In Alaska, for example, there's litigation and also regulatory changes that potentially for the first time could allow trust land, just like in the lower 48, in Alaska. That could change the relationship between Alaska Natives, the federal government, and the states. Similarly, in Hawaii, there are elections, well, there were elections until the Supreme Court enjoined them, to potentially establish a Native Hawaiian government. And the Department of the Interior has proposed rules for how to recognize that Native Hawaiian government, if it ever becomes reality, on the same basis as other Indian tribes across the country. These are sort of cutting-edge issues that maybe have historical connections in the lower 48, but are breaking new ground in both Alaska and Hawaii. And lastly, and at the risk of a junior faculty member disagreeing with a senior faculty member, since I see Professor Johnstone has returned, I would note that he said, I think, that the Montana Constitution is the only new constitution in the American West. To which I would also refer to the Apsalalike Nation, who adopted an entirely new constitution in the year 2001, beating Montana in terms of recency by about 30 years, approximately. And why did the Crow adopt an entirely new constitution? Well, again, it goes back to history, federal policy, and the distinction and difference between the way that federal policy had established and encouraged tribal governance and the way that the tribes historically and traditionally had governed themselves. So the Crow's new constitution sets up defined branches, a legislative and executive, and bases their legislative branch more closely on their traditional forms of government. So, sorry to disagree, but there is a more recent constitution in the American West. And in many ways, those issues, whether it's adopting new constitutions or dealing with these substantive issues, are indicative of tribal nation building that's going on across Indian country, but particularly in the rural American West. And that tribal nation building, I think, is a remarkable story, not just worthy of inclusion in panels and discussions like this one, but elsewhere too, especially when you consider that just over 50 years ago, the official policy of the federal government was that tribal governments should no longer exist, that those governments should be terminated along with the special relationship between the federal government and tribal governments. And so the revolution, the renaissance of tribal nation building has become one of the major stories across the rural American West. And importantly, that revolution and renaissance has been driven not by the federal government, not by state governments, but by tribal leaders and tribal governments themselves. And I think that's an important story to tell, and I encourage all of us to pay more attention to that story, particularly as it relates to these important issues across the rural American West. Thank you very much.
I've been considering time constraints. I'd planned on skipping the niceties and thanking you for having me, but I do want to thank Monty for that helpful summary of what we've heard today and then what was missing in it. So thank you for that. I do want to make another exception, if I can get this to work. I do want to thank John Daugherty, conference organizer, not for bringing me here today, but for in some ways inspiring my thoughts today. I saw John give this talk at the Western History Association conference this past fall, in which he basically admonished a room full of American Indian historians that we were thinking too narrowly about this topic, federal Indian policy. Instead, he made the rather obvious or insightful and in retrospect obvious comment that it's not federal Indian policy alone that drives change in Indian communities, of course, so we need to think more holistically about related policy areas like environmental or general economic policies, in my case, energy policies. So I'm kind of taking that to heart today, and I want to add some historical perspective to our discussion by explaining how the confluence of changing federal Indian policy in the 1970s and energy and environmental policy provided an opportunity for a revolution in American Indian law. Now, I say an opportunity because I think, as Monty just pointed out, these policies are not self-executing, certainly not Nixon's Indian self-determination policy of 1970. It would take Indian actors to move into that space and expand tribal sovereignty, but at least in the story I'll tell today, they did. So at the beginning of this tale, tribal governments did not control the development of their energy resources. At the end, they did, thus the revolution. This victory for tribal sovereignty, however, I must say, was tempered by some of those same external forces that created the opportunity in the first place. So to further drive John's message home today, I'm going to conclude by explaining how forces beyond federal Indian policy once again conspired, this time to thwart tribal attempts to transform this newfound control into cash. In re-examining the story this way, my hopes is that it will inform our debates about contemporary issues that tribes face today, like exporting tribal coal through northwestern ports to Asian markets. So first, the confluence. In the fall of 1971, the U.S. Department of Interior quietly published this kind of drab technical report entitled the North Central Power Study. In it, it involved 35 private and public utilities. The plan called for the construction of 42 power plants across the Northern Plains that collectively would produce more energy than any other nation in the world at the time, save the United States and the Soviet Union. Despite this scale, many within or beyond the region took notice. The country might have done better to pay attention, for despite its drab title and its relative secrecy, this was the first salvo in Richard Nixon's war of energy independence. Now, Nixon's energy policies are most typically framed as a response to the 1973 Arab oil embargo, but the fact of the matter is they had deeper roots. 2 years prior, in 1971, Nixon had delivered the first ever presidential address on energy policy. In it, he called for expanded domestic production, increased research and development into clean energy alternatives, and conservation measures so that, in his words, America could continue to know the blessings of both a high-energy civilization and a beautiful and healthy environment, right? It's a beautiful vision, but Nixon was no prophet. The president was actually responding to at least a decade-long trend that witnessed multinational energy firms who were well-versed in the growing instability in the Middle East, diversifying their portfolios with cheap Western coal underneath public and Indian lands. The North Central Power Study, thus, was a belated effort to coordinate this previously uncoordinated coal grab and assure the nation's energy security. Now, the coordination seemed especially warranted here on the Northern Plains because, I'm assuming some of you know, the coal here is not just any coal. The Powder River Basin coal found in this region is a subbituminous variety that has a lower sulfur content, particularly in relation to its eastern bituminous counterpart. This difference started to matter in the 1960s. Incremental advances in federal environmental policy culminated in the 1970 Clean Air Act, which those same energy companies had been intimately involved in drafting. Plus, they were intimately involved in drafting 1963 and 1967 versions of the Clean Air Act. The companies knew where this was headed. That 1970 Act specifically limited sulfur dioxide emissions. The energy companies knew that. Environmental policy, or this legislation, provided yet another incentive to diversify energy portfolios with low sulfur Powder River Basin coal. Finally, situated squarely in the middle of this targeted region lies the Northern Cheyenne and Crow reservations, tribes that have been becoming all too familiar with the desirability of their coal. Throughout the 1960s, again, those same energy companies had been descending upon these reservations, exploiting a broken, outdated legal regime to access tribal coal. The key provision of this legal regime was the 1938 Indian Mineral Leasing Act, a product of John Collier's Indian New Deal that was supposed to eliminate disastrous 19th century policies aimed at assimilation and exterminating tribal culture. Collier, Franklin Roosevelt's Commissioner of Indian Affairs, did that, but he was also a hopeless paternalistic progressive. Now, what I mean by that is that he wanted tribes to develop reservation economies in order to sustain this tribal culture that he thought was important. But he did not believe that tribes had the capacity to do this themselves. He feared their engagement with the outside world of industrial capitalism would compromise those norms and values he so wanted to preserve. So the 1938 Act was written to allow tribes to lease out their minerals to outside developers, but not develop them themselves. Collier then would insert the federal experts, right, to do the deals with the energy companies and then pass down the details of the deals to his less enlightened tribal wards for final sign-off. The problem with the system, of course, is that the federal trustees at the Indian office were at least as unprepared as Collier believed his Indian wards to be in doing deals with multinational energy firms. Lacking experience and expertise, federal officials failed to properly execute their trustee duty and simply relied on mining companies to propose which tracts of Indian land to open up for mining and largely dictating the terms. By the 1970s, the leasing system was out of control. Millions of acres of tribal land had been open to mining, returning an average royalty to tribal governments of 15.8 cents per ton. To put that number in perspective, the average price of Western coal in the Western market, Western coal in the open market in 1972 was $7.66 per ton. And then the revolution, right? In the summer of 1972, the Consolidation Coal Company, a subsidiary of Conoco, at the time the second largest coal producer in the country, bypassed the federal government and proposed directly to the Northern Cheyenne tribe a $1.2 billion coal gasification facility that would be supplied by a 70,000-acre reservation mine that would extract 30 million tons of coal annually, all of this on the reservation. The deal included a $2.5 million upfront bonus payment, but promised royalties of over $250 million over the life of the project. By Consol's own estimation, a new reservation town of 30,000 people would have to be created just to fill the jobs. This was actually in the proposal. This was supposedly a good thing. The size of this was staggering, but also alarming. As word leaked about the proposal to ordinary tribal members, many began to fear the impacts this scale of development would have on their tiny reservation. This is kind of a key here. Importantly, it was not the environmental impacts that most alarmed tribal members, but the fear of hordes of non-Indian coal miners descending on their reservation, disrupting those customs and norms that sustained their indigenous community. In other words, these people acted to save the tribe. Aided by area ranchers and the national environmentalists who tied Consolidation's project into the much larger North Central Power Study, tribal members demanded that their government halt all development until they could better assess impacts, right? And then something truly remarkable happened. Not only did the Northern Cheyenne tribal government halt all mining on their reservation, they then orchestrated a pan-tribal movement to prepare other tribes to plan for, to control, and to capitalize on their own energy resources. This may be astonishing to people in Montana, but they teamed up with the Crow to their west, the Navajo to their south, and other northern plains tribes, these energy tribes across the northern plains. And these groups worked in tandem with federal government agencies, energy agencies, tasked with increasing domestic production. So this would have been the Federal Energy Administration and then the Department of Energy when it was created. Importantly, not the Bureau of Indian Affairs. This new pan-tribal federal partnership then birthed eventually an organization known as the Council of Energy Resource Tribes. CERT then used federal funds to hire outside expert energy consultants to come in and work with tribal governments and tribal leaders to increase their expertise and, the institutional capacity of these tribal governments to develop their own resources, okay? For those of you paying attention, the rub is the law didn't allow them to do that, right? Recall the paternalistic 1938 Act only allowed tribes to lease out their minerals to outside developers, not take the lead in tribal enterprises of energy development. However, now that tribes had developed this requisite expertise in the eyes of the federal government, the old law had to go. In the early 1980s, in the context of Nixon's Indian self-determination policy and the rhetoric of energy independence, the legislative fix was relatively painless. Tribal groups, federal officials, even energy firms all supported the 1982 Indian Mineral Development Act, which finally paired sovereign authority with tribal capacity, sort of. The law authorized tribes to develop their own minerals in whatever manner they saw fit, subject, of course, always to final approval by the federal trustee. So it's a fairly happy story, right? It's a work of Indian actors to, I won't say expand tribal sovereignty, but to get the federal government to recognize an expanded sense of their sovereignty. And so the question that has to be asked is, well, where's all the sheiks of the Northern Plains, right? Where are the Native American Saudi Arabias? You won't find them. Unfortunately, the crushing conclusion to the story is that just as tribes secured the authority to control their own energy projects, federal fiscal and energy policies conspired to thwart advances. Ronald Reagan may have signed the 1982 Indian Mineral Development Act, but he did so with the same hand that decimated the federal Indian budget, including cutting the Department of Interior's entire tribal energy program, which was the backbone of the Council of Energy Resource Tribes' support. More damaging than budget cuts, however, was Reagan's energy policies. The president accelerated Jimmy Carter's phased deregulation of oil prices, and that produced a surge in domestic oil supplies as producers moved reserves into this suddenly unregulated market. This increase in domestic output was then met by an unexpected rise of non-OPEC producers increasing their production to take advantage of higher international prices after the 1979 energy crisis. At that point, OPEC's discipline completely broke down, and individual countries there started rushing into the market, or rushing their products into the market to capture this economic windfall. By 1983, the world was flooded with oil. The energy crisis of the 1970s had turned into the oil glut of the mid-1980s, and it's cheap oil that then collapsed the market for Indian energy at the same moment, almost simultaneous as the tribes securing authority to develop their own minerals. So considering time constraints, I'm going to leave you with that. I'll play with the implications of that if you'd like in the Q&A, but it's a happy and sad story that I'll leave you with. Thank you.
I want to thank the conference organizers and the organizers of this panel and my fellow panelists. But I want to especially thank you for listening and caring about these issues of criminal law and jurisdiction, not because they are the same that you might be facing in your rural areas, but because they're different. And they may never touch you, but they're so important to our fundamental justice in the United States that I think it's worthy of talking about. I come to you today with information based on my research and my advocacy in Indian country, looking at the civil rights and constitutional rights of Native American Indians under the U.S. Constitution. But I want to talk about the landscape of justice and jurisdiction, crime and punishment in Indian country as one of, from the federal government policy, civilization of the Indian. And I say that in quotes. And the way I see it is the criminalization of the Indian to reach the goal of civilization. And it happens across time, and it's happening today in a case that is currently pending before the United States Supreme Court called the United States versus Bryant. United States of America versus Michael Bryant off of the Northern Cheyenne Indian Reservation here in Montana. But first, let's talk about how we got to this fractured jurisdictional landscape. It's a landscape that has been shaped by United States Supreme Court decisions and congressional enactments, one that allows for or has caused jurisdictional gaps in tribal sovereignty, tribal jurisdiction over people who commit crimes on the reservation. So the result is Indian tribes are without jurisdiction over people who are non-Indians and commit crimes directly on the reservation. But also creates justice gaps for the Native American who happens to commit a crime on the reservation and is without specific U.S. constitutional rights that ordinarily would apply directly to anyone facing charges in federal court. Specifically, the right to counsel. Indians, because they are dual citizens, are subject to two different types of civil rights. One, the statutory right, the Indian Civil Rights Act provides of 1968, and one under the United States Constitution, the Sixth Amendment, that applies to state and federal courts. Because the Constitution doesn't apply to tribal members on the reservation, Indians have two different sets of rights that are going to be implicated depending on what forum we're talking about. That leads us to then the current case before the Supreme Court, the Bryant case, and the individual who is facing federal prosecution without having had the right to counsel for his prior convictions, and how that dilutes his civil rights under the U.S. Constitution. It starts with the story of Crow Dog in the Dakota Territory, a man who was charged with murder on the reservation against another tribal member, Spotted Tail, an Indian agent. So Crow Dog was charged with murder and prosecuted in federal court. This was after he was already subjected to the local laws of the tribe, the traditional laws with regard to crime and punishment on the reservation, the traditional method of bringing him into the justice system, for lack of a better word, within the tribe, and he was punished for the murder and sentenced to provide for the family of the victim, to provide money, to provide blankets, provisions, and some say banishment from the Indian Territory for several generations. Because Spotted Tail was an Indian agent, this had serious repercussions in the United States government. And the case went before the Supreme Court, but the U.S. Supreme Court found that there is no jurisdiction over Indian people when it's an Indian versus Indian murder on the reservation. Thus, the United States couldn't prosecute him. He had already been tried within the local laws of the tribe and sentenced, and they couldn't subject him to the federal death penalty. Swiftly, Congress acted then to pass the Major Crimes Act of 1885, which said that federal jurisdiction applies over Indian crimes on the reservation in order to bring some sort of semblance of justice, some civilization to the Indian, to provide him a forum by which these crimes could be punished. So the law has been on the books since 1885 and has numerous counts, the serious counts, rape, robbery, murder, arson on the reservation, go straight to federal court, but also can be prosecuted by the local law of the tribe. During this time period, in the 1880s, the Bureau of Indian Affairs created a different set of courts on the reservation, one called the Courts of Indian Offenses, or the Code of Federal Regulation Courts. There was absolutely no authority for this executive power to create a court system. They're not Article III courts, and they're not subject to the constitutional provisions that we know state and federal courts to be. Instead, the Commissioner of Indian Affairs just decided that the Indians needed to have a system by which they could be civilized. And the 1888 case, United States versus Claypox, is a good example of these types of CFR court cases. It's a case in which a Umatilla Indian was charged with rescue of another Indian who was incarcerated within the tribal jail, jailed on the tribe for adultery. This was one of the laws that was created by the Bureau of Indian Affairs. There were crimes that were not just theft and injuring others, but also adultery based on plural marriages, and most notably, the practice of Indian religion and speaking of Indian language. And the person could be faced with jail, loss of provisions, fined, by the local Indian agent who also served as a judge. They were enforced by the police, who were the Indian police on the reservation. Specifically, there was no right to counsel in these courts of Indian offenses. The idea was the Indian didn't really need someone to speak on his behalf. The Indian agent was there to benevolently set out the correction and the punishment for the Indian. So the idea that courts of Indian offenses were created to civilize the Indian. Also, major crimes went to federal court. Tribal courts had their own jurisdictions and their own systems, but they were prescribed by congressional enactment. In 1968, Senator Sam Ervin enactment, the Indian Civil Rights Act, created this special statutory right that applied to Native Americans facing crime and punishment on the reservation. Senator Ervin of North Carolina was seen as someone who was for civil rights. This allowed him to create the illusion that he was protecting the Indian while blocking the Civil Rights Act for African Americans in the 60s. So the Indian Civil Rights Act applies in 1968. The question was, is there a right to counsel for Indians on the reservation? At the time of the passage, non-Indians in state court didn't have the right to counsel for certain offenses, offenses that were petty or misdemeanor cases. So until 1963 in Gideon, the Sixth Amendment Sixth Amendment jurisprudence hadn't been developed. After Gideon, the Supreme Court said anytime you're facing incarceration for a felony offense, you receive the right to counsel. It wasn't until later in 1972 that another Supreme Court case in Argersinger did the Supreme Court said anytime you're facing incarceration, no matter what the charge, you need to have the right to counsel because our Sixth Amendment says that it's so fundamental having an attorney to defend your case that it would be against our system of justice not to have that. So the landscape was, at that point, the Indian Civil Rights Act didn't allow for counsel for Indians facing any sentences up to 1 year and beyond. And in a follow-up case in 1978, Oliphant versus Suquamish, the justices saw some justice gaps for people who were going to be hailed before an Indian tribal court on criminal offenses and found that tribes do not have jurisdiction to punish non-Indians committing crimes on the reservation. Specifically, the Rehnquist decision said that these are foreign courts to non-Indians, and people who commit crimes on the reservation shouldn't have to face a government that they have no part in. And so it was a particularly devastating case for tribal court jurisdiction, and one that was basically made up by Justice Rehnquist. An idea of implicit divestiture, which is completely contrary to the Indian canons of construction and congressional power over Indian country. That decision in 1978 left just jurisdictional gaps in which Native Americans could be prosecuted both in their tribal court and federal court without double jeopardy violations, but non-Indians were basically immune, not virtually, but completely immune from tribal court jurisdictions for crimes that they committed on the reservation. Unless the United States government decided to bring a charge against them in federal court, they could commit any number of crimes on the reservation and not be charged. States didn't have jurisdiction or an interest in particular states because of the relationships between the states and the tribes, or because of just the questions of who had jurisdiction at the time. In 2010, the Tribal Law and Order Act was passed that allowed sort of the backdrop for the next law that was passed in 2013. And it was based on these really moving testimonies of Indian women who had faced domestic violence, assault, and even serious crimes on the reservation, who felt that they weren't being able to secure justice in tribal courts. So the law extended sentencing for tribal courts to allow them to sentence their Indian tribal members and other members to longer sentences, but it still didn't address the non-Indian justice gap. So that law was signed into, Tribal Law and Order Act was signed in 2010, and it wasn't until 2013 that Congress passed the next complementary law, which was the Violence Against Women Act reauthorization of 2013, that said tribes do have jurisdiction over non-Indians, but only in domestic violence cases, and only if they have a relationship with the person, and only if they are facing a jury of their peers. That means non-Indians have to be in the jury panel, and they get the right to counsel and all United States constitutional protections. They didn't have the same requirements for any Indian facing any crimes or incarceration in tribal courts. So this leads us to the case currently before the Supreme Court in Michael Bryant, United States of America versus Michael Bryant, where he's facing a federal charge of domestic violence. This is a statute that was specifically created to target domestic violence in Indian country, and says that when you have 2 prior convictions for assault, domestic assault, your third one, you go straight to federal court. You can be convicted under the United States sentencing guidelines that has enormous sentence, even more than a conviction for assault with serious bodily injury on the reservation. So this was a really important landmark legislation. The problem with this from a civil rights, human rights, and constitutional law perspective is that Mr. Bryant, with his many, many convictions in tribal court, never had the right to counsel. And in fact, the government is relying on 2 prior convictions before tribal court that did not allow him to have the same right to counsels that you and I would see in state, municipal, federal court in order to secure a conviction. So in the end, I want to make it really clear that it's a policy that the government started with, that there's no right to counsel for Indians on the reservation, and that continued well into 2010, 2013, and one that continues today. We're not talking about the right to counsel in tribal court, but we're talking about how they use those convictions in federal court under our 6th Amendment constitutional rights. And I'm happy to talk about this more afterwards. Thank you.
Thank you. I realize that I'm between you and dinner, so I'll be very careful. A lot of yeasty material today, and I just want to take a minute to follow up on some of the stuff that was mentioned earlier. I, too, am grateful for the panelists. I learned a lot. First one I want to mention is I have some homework for you. I put on Twitter 3 background stories. We talked a little bit about the definition of sovereignty this morning, and I had a little encounter with George Bush on sovereignty, and you can look at it at your leisure. The second one is when you talk about the newcomer and the outsider in Montana, one of my favorite political commercials of all time is John Melcher and his talking cows. So I had to post that on Twitter. And the third piece is 4 years ago, I did a story for PBS where I followed candidates across Montana. And one of them, the story that we did for the NewsHour, was Denise Juneau and the Montana Native vote. And so I posted that on Twitter. So 3 pieces of background. Also wanted to mention that in some of the talks just a minute ago, I had a little different perspective that I wanted just to mention quickly. One of the few people probably that had a chance to interview both John Ehrlichman and Len Garment before they died on how the Nixon policy unfolded. And John Ehrlichman in particular was wonderful. He smiled and said part of it was just sticking it to Democrats, that they thought they could be ahead of these issues, and they saw such a small number, and they really saw it as a way to drive a wedge with the Democrats in Congress. He, though, thought one of the most remarkable moments was the return to Blue Lake, where you had on the Senate floor Nixon lieutenants working together with the most liberal wing of the Democratic Party to outmaneuver the centrist Democrats. The second one is on Crow and Cole, and this comes just from years of being around. But when I was a young reporter, I spent a lot of time writing about this, and remember Alan Rowland, who was then chairman of Northern Cheyenne, and environmental aspects were definitely a part of that debate. In fact, Alan said, you can't breathe coal, and that was kind of one of his driving forces. The great story that Alan used to tell that I loved was when they had decided they were going to reject the coal deal, they decided to fly back to Peabody, Illinois, and they had already voted no, but they took the plane and they went back there, and they informed the Peabody Coal that they were going to go a different route. And they said, why'd you come back here then? Why'd you come on the plane? And the way Alan told the story was, we'd never been to Peabody, Illinois before. So they took the ride. Also, the John Collier part, my uncle was a guy by the name of George P. Levada, and George's task was writing tribal constitutions working for Collier. And the way that George would tell the story about some of the complexity involved in how they tried to go about that task, I heard those stories over and over as a kid and kind of grew up with them. From this morning's conversation, I also wanted to follow up on a thread of who's new to the region. When Denise Juneau announced her candidacy for Congress a few weeks ago, she said that her family has 54 generations in Montana. And that could be an interesting standard if you want to use that for the debate about who's a newcomer and who's not. I also have Montana connections that run pretty deep. My grandmother used to give me a really bad time and say, how come you always tell people you're Shoshone-Bannock and you never mention that you're Assiniboine? And my grandmother's from Fraser, Montana, and is Assiniboine. And I used to tell her, well, Grandma, I grew up at Fort Hall. I know people there. I'm enrolled there, and that's where my background is. And besides, people are always abbreviating things, and I don't really want to be a showban ass. In 1903, my great-grandfather in Fraser, Montana, and great-grandmother, Walter Clark and Josephine Butch Clark, they had 11 children, and Walter Jr. Clark was gravely ill, and my great-grandfather made a vow that if his son was healed, he would have the greatest giveaway ever. And in 1903, that happened. His son was healed, Walter Jr. And so starting in 1903, they started a giveaway. And when my grandmother would tell me the story, she would talk about how significant this giveaway was. And she'd say they give away horses, which is like giving away a new car today. And that family pledge continues to this day in every June. It's called the Red Bottom Celebration in Fraser, Montana, and continues as a pledge from 1903. I, shifting gears a little bit, write a blog, TreyHuntReports.com, where I write about Native vote, and it really operates on the simple idea that neither this country nor the West can be what it wants to be unless there is representation and voices from Indian country. More and more with federal regulations, and the latest being the Affordable Care Act, there's a phrase in the law that says states and tribes. And the federal government is slowly coming around to the idea that tribes were governments that were part of the structure from the beginning and ought to be included in that. So one of the questions I've been raising is we've just been going through these primary votes, and Northern Marianas Island voted a couple of weeks or last weekend, and only 53,000 people participated in that. Yet there are 4.1 million American Indians and Alaska Natives. And it seems to me that given and tribes being part of this new discourse, that there ought to be that same sort of consideration for the primary election system. And in fact, I'm going to make it my mission over the next 4 years, not just to write about it, but to see what I can do that there be a primary that would be Indian country. It would actually be really easy to organize because tribal election offices are already organized and could, if they had the resources, pull it off. Another thing I want to mention in that same regard is Canada's recent elections had some really extraordinary lessons for how the elections might be conducted in the United States. The two that I'll just mention right now is one, that we've got to come up with a mechanism to get first past the post voting. And it was one of the Liberal Party's campaign promises, so we'll see if Canada actually executes it. And if you get past this idea of district systems, you have the opportunity to, for the first time, come up with a way that includes folks like Indian country, where there's a broader representation rather than just who gets past the first vote. The second one thing is, and I call it you got to show up. In Canada, they did a fabulous job of candidate recruitment. Today at the Smithsonian, Canada's Attorney General, who's from First Nations in British Columbia, spoke. And the idea of a member of parliament coming from that broad a win was because they went out and recruited people. And they looked across the broad spectrum and said, we need to have this as part of Canada's future. And that's the same kind of conversation that needs to occur in the United States. And I'm building a database of every Native American running for office in the country. And right now there are 73 American Indians and Alaska Natives and Native Hawaiians serving in 17 legislatures. So there is some beginning of a system. And here in Montana, this is the most extraordinary state there is for Native vote. And it's really hard to undersell how important it is. In 2003, there were only 2 Native Americans in the legislature. Then in 1997, then there was one more, then another one. And by 2007, Montana reached 10 seats, which was 6.6% of the legislature. And that's really striking when Montana is only 7.4% Native American. In fact, if you were to put Montana into terms of the national legislature or Congress, Congress would include 5 U.S. senators and 21 members of the House. That's how extraordinary the Montana story is. Part of what changed the game here in Montana, in addition to the tribes organizing and doing a great job with Native vote and getting people to register and then vote, was the 2004 election with Brian Schweitzer. The governor today mentioned the tribal flags in the governor's office and how significant that was as a symbol. That began with Brian Schweitzer. And what was extraordinary about his time as governor was the breadth of what he did. He would appoint Native people to jobs such as Weight and Measures Board, Poet Laureate. You look across state government, and it wasn't just Natives getting appointed to Indian jobs. It was getting appointed to everything. And he fundamentally, in his 8 years in office, changed the landscape of what people could do. I think partly that's why you have a Denise Juneau, who has the potential to be the first American Indian woman in Congress, because of that landscape that was changed by Brian Schweitzer. If Montana is the state with the most extraordinary plus sign, the flip side of that is Alaska. Alaska is almost 22% Native, and yet the representation doesn't come anywhere near that. This time around, there is a lieutenant governor, but there's still an awful long way to go. I wrote, in fact, I wrote a few weeks ago that if you want to know who Indian country's Barack Obama would be, that if you look at that 79 American Indians and Alaska Natives and state legislatures, that's where you would look, and look to the states and see what they're doing. And I'll just give you 3 names of people that if you want to follow their careers and see where they're going. Indian country's Barack Obama will be named Paulette Jordan from Idaho, Peggy Flanagan from Minnesota, or Denise Juneau from here in Montana. So, thank you.
Great. Well, thank you guys very much. It's important that we have this perspective here. And I'd like to just take a moment to build on some of the reflections that we've got, specifically starting with Monty's here about the inclusion of American Indians in the earlier panels and topics that we've examined today. And, it's not just that it's a Native dimension to these topics that we'd like to see added. For example, let's return to that sense of place topic where I raised my own question. And one of the respondents suggested that having a sense of place as the organizing theme for a future conference, that's a great idea. But I'd like to point out that the simple inclusion only gets us so far. Instead, we should stay attuned to some of the intersections. So, for example, what sense of place does a Native person have who is also a fisher, or a coal miner, or a logger, or a homeless person, or an organic farmer, or rancher, or mobile laborer, kind of getting outside of the normal categories that we oftentimes kind of pigeonhole people into. This is where, it challenges us to think more about the intersections and how these force us to think differently about these topics rather than just thinking about indigenous peoples and tribal nations in isolation, almost as if they were on like a parallel track. In my mind, that separate but equal little clause keeps kind of cropping up there. So focusing more now on this panel, really I'd just like to start by posing one question to the panelists, and then I'd like to throw it open to the audience. But where does the issue of federal recognition fit into your analytical focuses, such as economic development, criminal justice, voting, or some of the other ranges of topics that have been touched upon, here dealing specifically with the rural West?
I guess I'll start. Well, to the extent the body of law is called federal Indian law, and to the extent the rights and duties of the federal government are defined by the federal government, then federal recognition really defines who is entitled to those rights and duties under federal Indian law and who isn't. There's been a significant amount of controversy and even recent political blow-ups between the Obama administration and particularly House Republicans about the ways in which the Department of the Interior deals with accepting applications for federal recognition. And while those may be primarily politically motivated and evidence of partisan divide, I think it's a legitimate question to ask, how can you just define a fair process for recognizing a group of people, particularly when there's so much history and legacy of the federal government using various standards to try and define these groups of people, primarily for the reason of either limiting or eliminating them from the landscape. And so to have federal standards in some ways is completely inappropriate, but yet that's what defines the universe of folks who are eligible for federal benefits under federal Indian law. So.
Far outside my area of expertise, so I'll talk anyway. I would just say that the process of what I know of it, the process used for federal recognition is based on a need of tribal groups to show a prolonged and uninterrupted history in a certain place. So it's based on needing historical evidence in order to demonstrate we've been here in this place. But of course, so tribes have to go back to a history that in many cases is all about erasing. I mean, the history is all about erasing their presence from that place. So it's an incredibly difficult thing to do, not to mention the political blowback against that. So I don't know that it answers your question directly, but I would point, as a historian, I would point out the difficulty that tribes have in meeting the standards when the very history they have to pull upon, first of all, is largely not written by them, and is the whole history of it was the aim of it was to write them out of the history. So there is a move, I would say incidentally, there is a move to kind of incorporate more ethno-history, the history of tribal groups themselves into the recognition process, which maybe adds more justice to the system. I'm not positioned to say how that's come about, but I do know of that.
Mm-hmm.
In my work outside of criminal law, I worked with families, federally recognized tribes, governments, descendants, people who are tribally Native American but may not be federally recognized. And along the Columbia River, there are specific treaty rights that are given to even those who aren't federally recognized, a group of people called the Columbia Indian River Indians who didn't go back to the reservation with their tribes, but continued to live and work along the river. The interesting thing about criminal justice is that if you're non-native, you have more rights and the government has more responsibility to you. And so the issue in federal criminal cases is whether that person is Native American enough to be subjected to the Major Crimes Act or could be non-Indian enough to escape jurisdiction in tribal court.
I will agree with what was said, and just let me add how extraordinarily complicated it is. Just, again, over the mountains from here, the Lemhi Shoshone had a treaty, and by the 1920s, they were pressured to move to Fort Hall and become part of the Shoshone-Bannock tribes. They didn't. They refused. Many of the families stayed. And now they're pressing for recognition based on their original treaty and that they stayed. And it just shows that complexity of how you determine who has a government that's lasted throughout time.
Yeah, and for those people who have done some work on the survey, I would be interested in, kind of here. I can't imagine that you had this question there. You had that great question of, do you support tribal sovereignty? It would be interesting to hear, if Montanans support recognition efforts from some of these other peoples who might be mounting those, and if so, what does that look like? What does that mean?
Just to add to that, I think that'd be particularly relevant in light of the decades-long effort of the Little Shell Band of Chippewa here in Montana to seek federal recognition.
Right. Okay, it was just something I wanted to introduce, and give the panel an opportunity to share with the audience. So questions, please. Okay, go ahead.
I'd be interested in the panel's, excuse me, reaction or evaluation of the Cobell lawsuit, where there was a significant amount of money put forward after years of inadequate fiduciary duty on the part of the Department of Interior.
Just as a general reaction, and I wasn't involved in Cobell and wasn't involved in all the permutations of the case, but in my role representing a tribe in my prior work, in our dealings with the Department of the Interior, it became pretty clear, and I think largely as a result of Cobell, that what was guiding many of the actions of the department was not the best interests of the Indian tribes, but the potential for being sued and losing and having a significant settlement like Cobell. So I think the process of that and the threat of litigation and the ultimate outcome may have had impacts beyond just the individual Indian beneficiaries and the class.
do you think that the distribution of the final settlement was done in an equitable manner, or do you think there was some maldistribution of that?
I'm not really in a position to comment. I guess what I would say is, and admittedly, having worked in a capacity for a tribe with the BIA, this may reflect some bias, but given the allegations and the ultimate settlement and the facts and mismanagement that led to the settlement in Cobell, I think you could draw your conclusions about how the distribution and subsequent implementation of that worked.
My name's Reagan Germer. I'm just an attorney, and I have a question for Monty. What were you really going to talk about today? Since I heard about it, I already heard about it, and I was pretty fired up about it, and I just wanted to, maybe you could do like a 2-minute rendition of what you were really going to talk about.
Very briefly. The case before the Supreme Court right now relates to the potential diminishment of the Omaha Reservation in Nebraska. And the legal test for diminishment under prior Supreme Court precedent has always primarily relied on the explicit language of Congress and the legislative history surrounding that enactment, with a sort of subsequent third test or factor being whether or not the character of the land retained its Indianness, really, whether it's still Indian character. And more recently, in other cases, the Supreme Court has looked more toward the settled and justifiable expectations of non-Indian residents of the area and viewed tribal attempts to either exert sovereignty or, in this case in Nebraska, pass a liquor control ordinance that's specifically authorized by federal law as upsetting of those settled and justifiable expectations of the non-Indian residents. And particularly in the context of the survey's findings about whether or not tribal sovereignty is working well, it seemed to me that there's a link between the settled and justifiable expectations of non-Indian residents living on or near Indian reservations and exercises of tribal sovereignty that may help explain that definition. The other sort of part of it, I think, which is particularly ironic and pretty relevant, I think, to sense of place and definition of the rural West, is that the Supreme Court looks at settled expectations without an understanding of how those folks came to be in Indian country in the first place, which disrupted all of the expectations, much less land ownership and tribal homelands 150 years ago. And if it wasn't for the allotment policy and the history of federal Indian policy toward Indian tribes, there would be no non-Indians in Indian country. And yet now the Supreme Court looks to their expectations, potentially, to override the express language of Congress and exercises of tribal sovereignty. So in a nutshell, it seemed to me to relate to our topic.
A couple years ago, I was trying to find a literature about how tribes govern themselves and how vibrant their democratic institutions are and how they operate and how much variance there is, and I couldn't find anything. So could you give me any kind of view of how it operates? Is it so wide in the way tribes elect their representatives and make decisions that you can't make any generalizations? Or is there anything that you can shed light on this, whether you think they work well? Because, you know, if you're going to give tribe sovereignty, they have to have democratic institutions that represent the people of the tribe. So I'm just kind of curious, how are they, what do we know about it? And where can I find more information about it?
There's one answer. It depends on the tribe. And generally, I think the best answer about finding more information is to go talk to the tribes themselves. I mean, they are the ones who engage in their governments. Survey? I don't know that there's a wide range.
I mean, I'll just give you a kind of an example. Monty mentioned the Crows Constitution in 2001. The previous Constitution was in 1948 that essentially manifested a practice that has been in place since the federal government came and tried to negotiate treaties with the Crow. And to get around these powerful Crow leaders who kind of could mobilize their factions to say no to treaties, the federal government started requiring majority votes on whether to accept the treaties or not. And so that's, mid to late 19th century. By 1948, many members within the tribe actually start believing that to be a traditional value of the tribe. And so the 1948 Constitution, the legislature of the Crow government was every adult member of the tribe was in the Congress, to put it in our terms, which was, again, and then many Crow then defend this value as quintessential to their Crowness. And they find, at least in my case, that that's a very unruly governing structure when you're trying to do energy deals that are tied to fluctuating markets. And there may have been other reasons for the 2001 Constitution, but many on the Crow tribe believe that part of the reason for streamlining that process was to empower the executive more and empower the entire governing structure so that they could pursue economic development programs that were merely impossible. So just that wide swing of pendulum from a hyper-democracy to one that, I guess it's in a sense kind of like the U.S. structure, but it also reflects pre-reservation era Crow values. I mean, that happened in one tribe over the course of 50 years. So no one has taken up the effort to survey them all.
So, but the executive in your case, in the Crow case, is that an elected executive office?
Yeah, and another place you might want to start is taking a look at the work of Jean Dennison, an anthropologist. She studies Osage governance structures, and I bet you her footnotes would probably have a few more directions. But most of these types of studies that I'm familiar with are going to be, kind of tribe by tribe. Maybe you'll get some regional type things.
One of the complexities, I think, is that if you look at what's required for a democracy, it's not necessarily who has an election. And for example, in Shoshone leadership structures, there's very specific tasks. So you'd have a fish chief, fish boss, a peace chief, a war chief. It'd be very specific, and when the task was over, you'd move on to the next. And that idea, I think, is actually still around. It comes in the form of recall elections and things that we think of as a negative form, but it's just the idea that you're shifting for a specific task at the time.
I just wanted to add that tribes aren't given sovereignty, but it's a government-to-government relationship because they existed as a government pre-contact, but also that when I worked with legal aid in the Northwest, I was surprised that tribes elected members and leaders, because where I come from in the Southwest, it's a very different system. There's not a democratic vote, and people are called to leadership by their skills and expected to participate in the community through more traditional language-based and religious-based responsibilities that we have to each other in the community. And I would say that it's not democratic in the way that we think of that outside, but those are sovereign decisions, and they're very, very different region to region and tribe to tribe.
I have two questions. These may be a little naive, but one is for you, Barbara, about the issue of, because you speak about the tribes not having, the members of the tribe not having a right to counsel. But why wouldn't the tribes themselves pass something that said everybody had a right to counsel?
Tribes are preempted in making those decisions by the Indian Civil Rights Act by being told that these Bill of Rights apply when you're operating as a government. But then Congress didn't then recognize those tribes who had already developed systems of justice that weren't adversarial and that didn't need to have counsel involved. And so there might be a very good reason not to have a right to counsel if you're going to have a sentencing circle or a restorative justice system. But because you impose the adversary system, for me, it's then incumbent upon the adversary system to have parity on both sides. Tribes can and do make sovereign decisions to allow counsel in the adversary system and pay for it for those people who can't afford it, but that's a matter of resources. And tribes that don't have the resources to implement the adversarial justice system with a paid prosecutor, a paid judge, a bailiff, a court reporter, they often make that decision to then leave out counsel because it wasn't required or because it wasn't part of the system before, especially when counsel was prohibited. So these are sovereign decisions, but they're really made on the backs of these historical decisions that came with lots of other reasons why they didn't want to have the Indian to have a spokesperson. Is that helpful?
And the other question I had, which is a more general one and may also be a little bit naive, how much agreement or disagreement is there cross tribes? I mean, it seems to me all tribes have a desire to be, have more sovereignty, be more independent. And so if they were to all get together, wouldn't they be more powerful? Or are there such differences between tribes that it would be hard to get them to join together to get something done?
Yes. There is one of the oldest advocacy organizations, the National Congress of American Indians, was founded in 1944, precisely for that reason, to organize a national presence for tribes. But there are significant distinctions even in governance forms, constitution forms, tribes without constitutions, that make, on a tribe-by-tribe basis, sort of coalescing around particular issues very difficult. I think the coal export example is a perfect one, where interests don't always align.
I mean, I would just, think about the dysfunction of the U.S. Congress. And tribal nations are much more diverse than the states in the Union. So, yeah, I mean, there's certainly been multiple attempts to do this. There's a lot of diversity to try and coalesce. But there are great examples of times when that happens. In my case, the Council of Energy Resource Tribes, right, where these tribes that do share a common interest do kind of come together, pool resources for their advancement. Yeah, but I don't know, kind of across the United States, among all the tribes, there are organizations that, they got a lot of internal disagreements to wrestle with.
Doesn't that, because it wasn't your idea, if I understood it correctly, weren't you saying that you wanted to have representation but if the tribes are so diverse, how could you organize such a thing as tribal, I mean, who would speak for the tribes?
Well, every tribe has its own way of speaking, but in terms of broader representation, it could just be by the same way that everybody else is. One thing you could do, for example, is making sure that, say, legislative districts fit the same geography as the reservation boundaries, so that it makes it more potential for the right vote. My two people, Charles Trimble and Sam Deloria, were both with the National Congress of American Indians. This has been the late 1970s. And at those meetings, I used to talk about the power of counties and how concerned they were about the power of counties trying to get involved with Indian issues. And they just thought this great, overwhelming. So they set an outreach plan to meet with the counties and to try to come up with some way to have a conversation about shared interests and governance. So they went to the meeting for the first time representing NCAI, and when they're at the meeting, they heard the counties speaking. First time they had been to such a meeting, and the counties are saying, these tribes, they have so much power. And it's just interesting how these two sides had completely the opposite view of each other because they hadn't had the conversation. I'm one of those weird journalists that like numbers, and one of the things that I think is really extraordinary is in terms of the Congress, 0.037% is the number of Native Americans in Congress. And if the population's 2 or 3, and you can argue what definitions it is, at least ought to set that as a goal to get some sort of representation. The judiciary, by the way, is even worse. The judiciary is 0.011%.
Another thing to think about is that because Indian law is federal Indian law, these decisions from the Supreme Court have wide impact, especially in a case like Oliphant, where the non-Indian was challenging jurisdiction, went all the way to the Supreme Court, and it obliterated jurisdiction for all tribes across the nation. And Indians didn't have any say-so in that, tribal governments or individuals, whether they combined together or not.
And I'd like to add something to address your question. That, these types of, some of what you've heard from the panel today, especially, I think Jamie's example of, CERT gets together, they got together, they start to plan proactively in kind of this pan-Indian way, which, has been attempted since the 1640s. Miantanomi was one of the first ones to say, hey, guys, we need to kind of try to push back against this divide and conquer colonial mentality. And then you see these types of things where we get this, and then it's undercut in some other way, by the federal government, by certain policies that we don't necessarily have control over. And so this is one of these reasons as to why many Native peoples, why we say the colonial condition continues today. It's not left in the safety of the past, where we're all quite happy looking at it. But, because everything's better today? No, those problems still persist. I think we've got a question up here, too, at some point.
Monty, earlier you mentioned consultation, and it made me think of another C that I think is becoming more of a norm and an expectation for so many agencies, which is collaboration. And the formalization of collaborative organizations and an expectation, I think that those, shouldn't just pop up organically necessarily, but that agencies should be more proactive in cultivating them. So as someone who sent out letters to tribes saying, hey, please be part of our council, I thought, boy, they're probably receiving many, many of these letters from many agencies. And so I'm curious to hear the panelists' perspectives on the opportunities and or burden of kind of an increasing sense of collaboration as a layer in addition to consultation.
One of the real challenges of consultation is that wide, diverse group of Indian country. For example, in Alaska, many of the tribes are villages, and the village government simply doesn't have the resources to keep up with the consultation requirements from different agencies. Collaboration, it really depends on the moment, and part of it is what kind of relationship exists beforehand so that there's enough level of trust to be able to do something to make it work.
I was just going to mention, I can think of an instance in the energy side of things where tribes are be pushing against that collaboration as it can infringe upon, in their perspective, infringe upon their sovereignty to do what they want to do with their resources. So the National Environmental Policy Act requires that any time before a government takes a major federal action that they do all types of consultation to evaluate the social and environmental and even cultural impacts of that decision. And the tribes who want to develop their own resources have pushed in recent years to, pound sand, as my father-in-law likes to say. Like, it's our resources. We should do what we want to do. And so in 2005, there's a law passed in Congress that authorized tribes to put together these things called tribal energy resource agreements, these master agreements that if the tribes present them to the federal government, the EPA, and it shows that they have the capacity to manage their own resources, that they will do their due diligence, that they have tribal ordinances in place to mitigate any environmental damage and so forth, that the federal government says, okay, you've got a TERA, right, and you can bypass the collaboration. Now, since that's passed, I don't know of any tribe that's actually done that, but there was a movement to do that, so to reduce another bureaucratic hurdle to the exercise of sovereignty.
Hi, that's kind of relevant to my question. With the work that I've been doing on my own reservation, which is the Blackfeet, I've noticed that a lot of these laws, like NEPA and TIPO, they just don't seem to have, okay, I'll rephrase it a different way. I would say it seems like it's approached not as a requirement, but definitely encouraged that there be some development of the land, whereas that's not always what like everybody on the reservation would like to do. And I'm thinking, I'm not sure if it was actually on her reservation or not, but I'm thinking of many years ago, like Winona LaDuke, her tribe was trying to, or she was trying to get a piece of land for her tribe, and there was a logging or some kind of development company that also wanted it, and she had to prove that she could economically use that land and make more money than the company in order to be able to get the lease. And so I guess I'm just wondering, like, it's not a requirement, but it does seem encouraged, and I just wanted to hear what you have to say about that.
In some ways, I think this goes exactly to Jamie's presentation and the ability and authority of tribes to make their own decisions and have those decisions respected about development on their own reservations. And in some ways, it ties into tribal governance, too, because if the people on the reservation feel one way about development and the tribal government feels a different way, you're going to have disagreement between the governed and the governees about what to do on the reservation. So economic development, I think, raises a whole host of other challenges, both about governance and sovereignty and the federal trust responsibility, and outside influence that is for another panel, if not a conference.
At the risk of defending federal officials on this point, you're absolutely right. There's been an insinuation that development is what is necessary and desired on reservations. And in the implementation of federal laws that are supposed to govern that development, I found in my work that federal officials are constantly believing they need to push forward in order to uphold their trustee duty, that as fiduciaries over tribal resources, that means responsibly managing them to get the best economic return possible. That kind of pervaded federal officials' view of fulfilling their trustee duty for a long time versus the trustee duty may be fulfilled by recognizing the wishes of the people there. So it's not a defense, but an understanding of the motivation. I mean, when we're talking about in the 1960s, BIA officials in the regional office of Billings, Montana, putting together energy leases for the Crow or the Northern Cheyenne. I mean, they're not insidious people. They're genuinely believing they're carrying out their mandate, I think. And also the tribes are pushing forward at that time in my story, right? The tribes are because of the poverty on the reservations, they are interested in the revenue. So again, I know that's a general question, I'm relating it back to my research, but there is kind of I hate to use the term awakening, but there is an education that is taking place about the impacts of development in my story in the 60s and 70s, and then a real debate within the tribes over the costs and benefits of that, and where do we come out on whether we want it. What they do all agree on is that they want to control it. In the end, they all want to control it, and there's some debate about then what that translates to as far as a development project.
Okay, I think we'll probably make this the last question.
Thank you. Chris Musty, University of Montana. One of the things that struck me in analyzing the poll data and that I would like your feedback on is that we saw this very strong I don't know if you want to call it a sense of opposition or uncertainty or discomfort with the general idea of tribal sovereignty. But then when we ask about sovereignty over natural resources, there's vast support for tribes controlling their own land, tribes deciding whether they want to do things as controversial as coal development, tribes repurchasing tribal lands, and I've only been in Montana for 12 years, and I've seen periodic political controversies over these issues. And more recently, the two questions we asked about with the CSKT tribes gaining control over the former Kerr Dam and the Water Compact, which just passed the legislature this spring, both of those garnered majority support in the survey. And so one of the things that, just thinking about this in terms of what we know about public opinion and public policy more generally, this might be explained by the fact that when something is an issue that's not settled or hasn't been passed by the government, that things are incredibly controversial once they become a fait accompli, then it's no longer controversial. And the fact that it is settled law, that it is a compact that's passed through the state, and obviously it has to go through the Congress. But once something is settled legally or settled by governmental decision, then all of a sudden public opinion shifts to some extent in that favor. I wonder if you could speak to the extent to which this dynamic you see, in, if in fact it's true in this case, if this is something that you've seen in other tribal policies, for example, fishing rights in the Northeast, or energy development, or other tribal claims to land or to control their own destinies in other policy areas. If that's a pattern that we see over time that might give us a little bit of optimism about the future, or if that's the wrong way to think about this. Thank you.
In the Pacific Northwest, when the battles over salmon were intense, that division was so great, and I think part of it is language. In 1977, I was working for the Arizona Republic, and we did a series on federal Indian policy and actually kind of pre-Cobell on a lot of the costs of energy development versus what people were paid. We surveyed tribes across the country, and in every single tribe, the top question was, what do you think is most important? And tribal answer was sovereignty. And except for one, and curiously, that one tribe was Navajo. And if you think about how language is used, Navajo, it didn't matter. The geography took care of it. Navajo was sovereign no matter what anyone said. And so they didn't even need to think about it. And the other thing is, one thing that's changed in the rural West in the last really decade, I think, is the number of tribes that are largest employers in a rural county. And so more and more people think of sovereignty as their jobs. And whether it be at an enterprise or a natural resource business, they see that connection. Maybe they won't use the word sovereignty, but they see the connection with the tribe in their paycheck in a really positive way.
One of the issues that I see is that people, when they're thinking about sovereignty in the abstract, they can fall back on some maybe some stereotypes, and the Indian being the preserver of the natural land and the protector. And that same stereotype operated to the opposite for the criminal justice systems, where non-Indians didn't see justice in the traditional forms of reparations and restoration if they didn't have an adversary system, and so they were lawless, and the words were savage and lawless, and we can't trust them to have non-Indians in front of tribal courts. But when you're dealing with a specific issue where we know what we're talking about, we know what's going to win or lose, like can the tribe down the river have my water rights or operate under the Clean Water Act to impose more restrictive sovereign decisions, then it might become more contentious.
Yeah, back to the poll numbers. I was surprised to see the number of support for development, energy development. I'm taking in my mind on tribal lands by Montanans. And I'm not really sure what to make of that. I don't know if it's a streak of Western independence, let the people do what they want with their stuff. I don't know if it's fine, let them sully their reservations. They'll produce electricity for us. And there is a longer history of that in the American Southwest. Let's produce dirty coal-fired power plants far away from the beautiful, booming Sun Belt and have them transport the electricity in. That's a good idea. But I don't know about. It'll be interesting to see the regional play of where this comes, because you're not going to get that response in southeastern Montana by ranchers that are part of the Northern Plains Resource Council. Because tribal development of resources there can impact their water, their air. You also may not get it here in Missoula. I mean, as I understand, wasn't there didn't the Missoula City Council or something try and sue the Crow, or they've at least launched their petition against the Crow's desire to transport coal through here to those northwestern ports, fearful of the emissions that will come off the coal trains and its contribution to global warming. So I was intrigued to see that. I don't have an explanation, but there's some thoughts that it would be fun to figure out if they're right.
Of course, Missoula also adopted Indigenous Day, so Right. I mean, I think as you said this morning, Chris, this data was particularly vexing, so much so that it crashed your whole PowerPoint, which I thought was appropriate that the tribal law and policy data crashed your PowerPoint. That's indicative of these complex issues, I think. And part of it, and it ties into what's been said, but misconceptions about what tribal sovereignty means could play a role. You hear the tribal members all get per capita checks. Every tribe's rich because of casinos. Those are aspects of tribal sovereignty, sort of, that people may think of when they think of tribal sovereignty that are not true. And the same goes when you have concrete examples of tribes engaging in activities that, for the most part, people are okay with. That's different than thinking of tribal sovereignty in the abstract and perhaps drawing in some of these misperceptions and given the need to understand, at least in my view, history and the development of tribal sovereignty. It's easy to draw different associations that may or may not actually reflect tribal sovereignty.
Great. Well, I think on that note, let's thank our panel.